Hello, friends. Welcome to the 18th session. We are discussing Section 9 of the CGST Act and the circulars which are issued with respect to Section 9. Yesterday, we have discussed the circular number 80. I'll just open the file. Yeah. Circular number 80. And now, today, we'll be starting with circular number 81 of 2018, which is dated 31st December 2018. It says clarification regarding GST rate for sprinkler and drip irrigation system, including the laterals. Representations have been received seeking clarifications as regard the scope and coverage of entry number 195 capital B of Schedule 2 of Notification number 1 of 2017 Central Tax dated 28th June 2017. The entry number 195 capital B was inserted while Notification number 6 of 2018 dated 25th January 2018 and reads as under. So basically this entry was inserted 195B from 25th of January 2018, which is chapter heading number 8424, sprinklers, drip irrigation system, including laterals, which is taxable at the rate of 6% plus 6%, that will become 12%. Doubts have arisen as in certain cases a view has been taken in the field that this entry would not cover laterals of sprinklers and sprinklers irrigation system, while laterals of drip irrigation are covered in this entry. So meaning thereby there was a dispute whether the laterals of sprinklers and the sprinkler irrigation system will be covered in this entry or it will be only for the drip irrigation laterals. So therefore, the reply and the clarification given is the matter has been examined initially with effect from 1st July 2017. All goods falling under HS 8424, namely mechanical appliances, whether or not hand operated, for projecting, dispersing, or spraying liquids or powders, spray guns, and similar appliances, steam or sand blasting machines, and similar jet projecting machines, other than fire extinguishers, whether or not charged, were placed under 18% slab. So with effect from 1st July 2017, these were placed under the 18% slab. Subsequently, on the recommendation of the GST Council, the item, namely nozzles for drip irrigation equipment or nozzles for sprinkler, was placed under 12% GST slab rate. And the entry number was 195 capital A with effect from 22nd of September 2017. Upon revisiting the issue of GST rate on micro irrigation, including drip irrigation system, including laterals, the GST Council recommended 12% GST rate on micro irrigation system, namely sprinklers, drip irrigation system, including laterals. Accordingly, the said entry 195B was inserted in notification number 1 of 2017. So therefore, when the issue was revisited, then the micro irrigation, including the drip irrigation system, including laterals, the rate which was recommended was by the council was 12%. So therefore, the entry of 195B was inserted. The micro irrigation, sometimes called localized irrigation, low volume irrigation, or trickle irrigation, is a system where water is distributed under low pressure through piped network. So the water is getting distributed through a piped network, but under a low pressure in a predetermined pattern and applied as a small discharge to each plant or adjacent to it. The traditional drip irrigation using individual emitters, subsurfaces drip irrigations, micro spray or micro sprinkler irrigation, and mini bubbler irrigation all belong to the category of micro irrigation method. Therefore, the term is sprinklers in the said entry 195B covers a sprinkler irrigation system. It covers that. Accordingly, sprinkler irrigation system consists of nozzles, lateral, and other components would attract 12% rate. So therefore, the clarification came that the rate will be applicable, the rate which will be applicable will be 12% and not the 18%. So therefore, the answer would be, it is not only the entry 195B is not only limited to drip irrigation system, including laterals, but it is also laterals which are for sprinklers. So sprinkler laterals also and sprinkler irrigation system, both are covered, and therefore the rate would be 12%. Moving to the next circular, which is circular number 82 of 2019, 1st January 2019. This is the first circular of 2019. Applicability of GST on various programs conducted by Indian Institute of Management. See, generally it happens that we consider uh, educational institutions and the services provided by the educational institutions are exempt. And therefore, a lot of queries, a lot of clarifications are sought time and again. So this is again with relation to the various programs. For example, that executive program, if it is being conducted by the IIMs, then whether applicability of GST would be there or not, that is the question. Anyways, since we are here to read threadbare, this series is for that purpose. I'll be reading the entire circular. I'm directed to invite your attention to the Indian Institute of Management Act 2018, which came into force on 31st January 2018. According to the provisions of IIM Act, all the IIMs listed in the schedule to the IIM Act are institutions of national importance. They are empowered to grant degrees, diplomas, and other academic distinctions or titles, specify the criteria and process for admission to courses or programs of study, and specify the academic contents of programs. Therefore, with effect from 31st January 2018, all the IIMs are educational institutions as defined in notification 12/2017, as they provide education as a part of a curriculum for obtaining a qualification recognized by law for the time being in force. So the answer is very clear that IIMs, whatever qualifications they are providing or degrees they are providing, they are being covered or as the educational institution, and therefore the services are exempt. At present, Indian Institute of Management are providing various long duration programs, 1 year or more, for which they award diploma, degree certificate duly recommended by the board of governors as per the power vested in them under the IIM Act. Therefore, it is clarified that services provided by Indian Institute of Management to their students in all such long duration program, 1 year or more, are exempt from levy of GST. As per the information received from IIM Ahmedabad, Annexure 1 to this circular provides a sample list of programs which are of long duration, 1 year or more, recognized by law and are exempt from GST. For the period 1st July 2017 to 30th January 2018, IIMs were not covered by the definition of educational institutions. So this duration, it was not covered within the definition of educational institutions as given in 12/2017. Thus, they were not entitled to exemption under serial number 66 of the said notification. However, there was a specific exemption to following three programs of IIMs under serial number 67 of 12/2017. So they were not exempted in serial number 66, but there was a specific exemption given to three programs in serial number 67, which were those 2 year full-time postgraduate management in programs in management for the postgraduate diploma in management, to which admissions are made on the basis of common admission test, which is CAT, conducted by the Indian Institute of Management, or fellow program in management, or 5 years integrated program in management. For these three, the exemption was there. Therefore, for the period 1st July 17 to 30th January 2018, exemption would be available only to three long duration programs which are specified above. It is further clarified that with effect from 31st January 2018, all IIM have become eligible for exemption benefit under serial number 66 of notification 12/2017. As such, a specific exemption granted to IIM by serial number 67, which we have just read, has become redundant. The same has been deleted from notification by notification number 28 of 2018, dated 31st December 2018, with effect from 1st January 2019. So it has been deleted, whatever was there in serial number 67. So therefore, it is now included in serial number 67, and all such programs, long duration programs, are exempt. For the period 31st January 2018 to 31st December 2018, two exemptions under serial number 66 and under serial number 67 of notification number 12 or 2017 are available to the IIMs. The legal position in such situation has been clarified by Honorable Supreme Court in many cases that if there are two or more exemption notifications available to an assessee, the assessee can claim the one that is more beneficial to him. Therefore, from 31st January 2018 to 31st December 2018, IIMs can avail exemption either under serial number 66 or under serial number 67 of the said notification for the eligible programs. In this regard, following case laws may be referred. So these are four case laws which are referred in the circular, in which the Honorable Supreme Court has categorically stated that whatsoever exemption is more beneficial, that can be adopted in case multiple exemptions are there. Indian Institute of Management also provide various short-term programs for which they award participation certificate to the executives, professionals, as they are considered as participants of the said programs. These participation certificates are not any qualification recognized by law. Such participants are also not considered as students of Indian Institute of Management. Services provided by IIMs as an educational institution to such participants is not exempt from GST. Such short duration executive programs attract a standard rate of 18%. As per information received from IIM Ahmedabad Annexure 2 to this circular, provides a sample list of programs which are short duration executive development programs available for participants other than students and are not exempt from GST. So therefore, this they are clarifying. First, if it is a short duration, that is less than 1 year, and if it is a certification program wherein only a participation certificate is given, then that would not constitute an educational program, and it will not be a service which is provided by an educational institution. And the other thing which they have added is that the participants will not be considered as the students of IIM, and therefore the exemption will not be available. Following summary table may be referred to while determining eligibility of various programs conducted by Indian Institute of Management for exemption from GST. 1st July 2017 to 30th January 2018. For this period, these were the programs that we have already read above. The three programs earlier, and then the second part of the table. Then 31st January 2018 onwards, all long-term duration programs, 1 year or more, conferring degree diploma as recommended by the Board of Governors as per the power vested in them under the IIM Act, including 1 year postgraduate programs for executives. These were exempt from GST. And all short-term or short duration executive development programs or need-based specifically designed programs less than 1 year, which are not a qualification recognized by law, those are not exempt. So therefore, the two entries that shows the exempt and non-exempt is from 1st July 17 till 30th January 2018, only three which we have read, that is there in serial number 67, is exempt. And the second part of the table is not exempt, because 1 year postgraduate programs for executives, any program other than those mentioned in serial number 67, all short-term duration executive development programs, this is not exempt. So if something is not included there in serial number 67, it is not exempt, as simple as that. Whereas from 31st January 2018 onwards, any long-term program which is for 1 year or more is exempt, and any short-term duration program is not exempt. As simple as that. We can keep this in mind, and accordingly we can identify whether it is exempt or not. Now moving to the next circular, which is 83 of 2019. 83 of 2019, dated 1st January 2019. It says applicability of GST on Asian Development Bank and International Finance Corporation. So if there is any transaction by Asian Development Bank or Indian Financial Finance Corporation, then what is the status of GST applicability on that? Representations have been received seeking clarification regarding applicability of GST on Asian Development Bank and International Finance Corporation. The matter has been examined. The Asian Development Bank Act 1966 provides that, notwithstanding anything to the contrary contained in any other law, the bank, its assets, properties, income, and its operations and transactions shall be exempt from all the taxation and from the customs duties. So it says it overrides, and it says by way of a non-obstant clause that it will be exempt from all kind of taxes and the customs duties. The bank shall also be exempt from any obligation for payment, withholding, or collection of any tax or duty. DEA has already conveyed by letter number so and so addressed to ADB that taxable services provided by ADB are exempted from service tax. So this was the situation in service tax. And when it comes to International Finance Corporation, it says similarly IFC Act 1958 also provides that, notwithstanding anything to the contrary contained in either law, the corporation, its assets, properties, income, and its operations and transactions authorized by the agreement shall be immune from all taxation and from all customs duties. The corporation shall also be immune from liability for the collection or payment of any tax or duty. So this also immunes. Now further it says State Mumbai wide final order dated 17th October 2016 in case of Coastal Gujarat Power Limited has held that when the enactments that honor international agreements specifically immunize the operations of the service provider from taxability. I'm reading it again. In case of Messrs. Coastal Gujarat Power Limited has held that when the enactments that honor international agreements specifically immunize the operations of the service provider from taxability, a law contrary to that in the form of 66 capital A of the Finance Act will not prevail. This was in relation to the service tax. With the provider being not only immune from taxation but also absolved of any obligation to collect and deposit any tax, there is no scope for subjecting the recipient to tax. There is no need for a separate exemption, and existing laws enacted by the sovereign legislature of the union suffice for the purpose of giving effect to agreements. Accordingly, it is clarified that the services provided by IFC and ADB are exempt from GST in terms of provisions of IFC Act and ADB Act. The exemption will be available only to the services provided by ADB and IFC and not to any entity appointed by or working on behalf of ADB or IFC. So now they have made it very clear that they will be following the mandate which is there in IFC Act and ADB Act, and therefore it will continue to be exempted even in GST. Now, let us move to the next. This is circular number 84. It is dated 1st January 2019 again. It says clarification on issue of classification of service of printing of pictures covered under 998386. Now, this is something which is very important. And a lot of confusions, whether it is going to be goods, whether it is printing, a lot of confusions were there, which has been clarified earlier also. And now again, it is a clarification which is there. Let us read it. It has been brought to the notice of the board that the service of printing of pictures correctly covered under service code 998386, photographic and videographic processing services, is being classified by trade under service code 998912. Printing and reproduction services of recorded media on a fee or contract basis. The two service codes attract different GST rate of 18% and 12% respectively, and therefore wrong classification may lead to short payment of GST. So therefore, if you, first one is photographic and videographic processing services. Second is printing and reproduction services of recorded media. Printing and reproduction of the recorded media on a fees or contract basis. So these two are there. In first case, rate is 18%. In the second case, the rate is 12%. And therefore, the anticipation is if there is any misclassification, then it may lead to the short payment of tax. In spite of paying 18%, you might pay 12%. The matter has been examined. According to explanatory notes to the scheme of classification of services, the service code 998386 photographic and videographic processing services includes developing of negatives and printing of pictures for others according to customer specifications such as enlargement of negatives or slides, black and white processing, color printing of images from film or digital media, slide and negative duplicates, reprints, etc. Developing of film for both amateur photographers and commercial clients. Preparing of photographic slides, copying of films, converting of photographs and films to other media. This is what is there in the explanatory notes. Further, according to explanatory note, the service code 998912 is printing and reproduction services of recorded media on a fees or contract basis, which clearly excludes color printing of images from film or digital media, audio and video production services. So this is specifically excluded. In view of the above, it is clarified that service of printing of pictures falls under service code 998386 photographic and videographic processing services, which is taxable at the rate of 18%, and not under 998912, which is printing and reproduction services of recorded media on a fee or contract basis of the scheme of classification of service annexed to notification number 11 of 2017. The service of printing of pictures attracts 18% falling under item 2 against serial number 21 of the table in the notification 11 by 2017 dated 28 June 2017. So therefore, printing of pictures will fall into 998386, which is attracting 18% of the right, and not which is attracting 12%, which is 998912. We have covered 84. Let us see 85. Let us cover this 85 also for the time being, and then rest will cover up tomorrow. It is again 1st January 2019, circular number 85. Clarification on GST rate applicable on supply of goods and beverages services by educational institutions. If educational institutions are supplying food or beverages, then what will be the rate of GST applicable to them? Representations have been received seeking clarification as to the rate of GST applicable on supply of food and beverages services by educational institution to its students. It has been stated that the words school, college appearing in explanation 1 to entry 7 of notification 11 of 2017 give rise to doubt whether supply of food and drinks by educational institution to its students is eligible for exemption under 12 of 2017, serial number 66, which exempts services provided by educational institution to its students, faculty, and staff. The matter has been examined. Notification number 11 of 2017, dated so and so, serial number 71, prescribes GST rate of 5% on supply of food and beverages services. Explanation 1 to the said entry states that such supply can take place at canteen, mess, cafeteria of an institution such as school, college, hospitals, etc. On the other hand, notification 12 of 2017, serial number 66, clause A, exempt services provided by an educational institution to its students, faculty, and staff. There is no conflict between the two entries. Entries in notification number 11 of 2017 prescribing GST rates on services have to be read together with entries in exemption notification 12 of 2017 dated so and so. A supply which is specifically covered by any entry of notification 12 of 2017 is exempt from GST, notwithstanding the fact that GST rate has been prescribed for the same under notification 11 of 2017. Therefore, supply of all services by educational institution to its students, faculty, and staff is exempt under notification number 12 of 2017, serial number 66. Such services include supply of food and beverages by educational institutions to its students, staff, and faculty. As stated in explanation 3.2 of notification 12 2017 dated 28th June 2017, chapter section heading group or service codes mentioned in column 2 of the table in notification 12 of 2017 dated 28 June 2017 are only indicative. A supply is eligible. Now this is important. A supply is eligible for exemption under an entry of the said notification under the description given in column 3 of the table leaves no room for any doubt. There cannot be any doubt. Accordingly, it is clarified that supply of food and beverages by educational institutions to its students, faculty, and staff, where such supply is made by the educational institution itself, is exempt under notification number 12 of 2017, serial number 66, with effect from 1st July 2017 itself. However, such supply of food and beverages by any person other than the educational institutions, based on a contractual agreement with such institution, is liable to 5% GST. So therefore, if educational institution is not directly providing these services and it is provided by some other person with whom the educational institution has entered into a contract, then in that case, 5% rate will be applicable. In order to remove any doubts on the issue, explanation 1 to entry 7 clause 1 of notification 11 of 2017 has been amended by notification number 27 of 2018 dated 31st December 2018 to omit from its words school college. Further, heading 9963 has been added in column 2 against entry serial number 66 of notification 12 of 2017 dated 28 June 2017, while notification number 28 of 2018 dated 31st December 2018. So therefore, they have already amended this and they have deleted the word or omitted the word school and college from the entry itself. So now one thing is very clear. Any services which is being provided by educational institution to its students, faculty or staff is exempt. But if it is not directly provided by them, then in that case, the exemption may not arise and the applicability would be there depending on the kind of the service which is being provided. So friends, we have done up till notification number 85. And from notification number 86 onwards, we'll be taking it ahead on the next day. Thank you. Thank you very much.